Thank you, my lord. So just finishing off then Mr. Maynard's arguments, I was just dealing with his case on the test to be applied for sanction of the plan. And I've largely dealt with that. But we see the other flaw in his arguments is that it rests on the proposition that in the relevant alternative of a SAR, the interests of creditors are subordinated, is the word he uses, to those of customers. And we say that's wrong, or at the very least grossly oversimplifies the position. If we can go to Authorities Bundle 1 at Divider 4, you have the Water Industry Act, and the relevant provision for these purposes is Section 23, which you looked at. And it's 23 sub 1. And the point we make in relation to that is that under sub 1 and specifically subparagraphs A and B, the special administrator is required in effect to manage the company for two objectives. The first is achieving the purposes of the order and in a manner which protects the respective interests of the members and creditors of the company. And both those objectives have equal weight. Neither has priority over the other. And we compare that with the position in other legislation, in fact. And if you go forward 2 tabs to tab 6, you have the Energy Act, exactly. And it's interesting and instructive, we suggest, to note the contrast with subsection 3 of that, because that is structured differently. And in that case, the interests of creditors are subordinated to the objective of the energy administration. And that is a very different approach. Now, the most that can be said in relation to a Water Industry Act Special Administration is that if there is a conflict between the two objectives, then the administrator is required to balance those, and provided he does so reasonably, then presumably the court's going to be slow to interfere with his decision. But it doesn't, that isn't a subordination, that's a balancing. And if you take something like the timing of the transfer, which the administrator would have to think about, well, he's got to balance that. And there's nothing in the cases that says there is a subordination. The judge referred to my Lord Justice Patten's judgment in Metronet, which we respectfully don't take any issue with, but it doesn't say that there's a subordination. It just says exactly what I've submitted, that the administrator has to balance, and if he balances, well, the court's going to be fairly slow to interfere if it thinks the conclusion is one he's reached reasonably. So we don't accept that the premise underlying this contention about subordination of creditors' interests is made out in any event. I've dealt with the suggestion that Ofwat's view should have been ignored by the judge. We say that's not seriously arguable. The judge was clearly entitled to have regard to what Ofwat said. It would have been very odd if he hadn't placed some weight on that. On costs and uses of the financing, I've largely dealt with this. If you go to my learned friend Mr. Day's skeleton argument, which is in Core Bundle 2 at Divider 16, and if you go through to 392, so paragraph 39, his sort of starting point is the 443 million figure, which is put as being the costs for the super senior funding under the plan, and I've explained already why that figure is not reliable. He then cites in paragraph 40 the cost of borrowing, in essence, the same figure in the special administration, which is, he puts as 65.93 million. And essentially all he's done there is taken the same figure of 1.388 and applied the administration rate of interest as per Mr. Cowlishaw, I think, and ignored all the fees and costs. Now, I'm going to come back to that, why that's unreliable, because that's part of our respondent's notice. As you see at 41, I mean, ultimately, the problem he has in any case is the point he acknowledges in the second sentence of 41, that the judge effectively accepted his figures. We say in part wrongly, but came to the conclusion that actually they would be balanced out, and there wasn't a basis for concluding the costs of a SAR would be less than the costs of a plan. And there is no, I mean, I'll come back to it as well in paragraph 47, that there is no arithmetic error, because the figures Mr. Day relies on in paragraph 47 of his skeleton argument in our submission are wrong for the reasons I've already explained in relation to both the 443 million and also the 800 million figure. But ultimately, there isn't any basis for overturning the judge's evaluation on this question. Now, if we turn then to the respondent's notice, so our primary position is that ultimately the judge came to the conclusion that the costs balanced out. As he said in the judgment, there's no basis for thinking that the costs of the SAR would be less than the cost of the plan. And our primary position is that's a reasonable evaluation by the judge. He's looked at all the evidence. He's come to that conclusion. There isn't a basis for overturning it. If my learned friend Mr. Day is right that it is open to this court to effectively overturn that and get into the weeds, as it were, then we make some points by way of respondent's notice. The first is that we say ultimately the judge should have concluded that the costs of a SAR were more than those of a plan, the first point we make is that Mr. Cowlishaw put forward properly compliant Part 35 expert evidence by which he estimated the monthly costs of running a SAR. And if you go to supplemental bundle 1, divider 5, page 99, there's a section beginning at page 99 of the bundle that goes all the way through to 107, where he essentially set out what he called the SAR overlays. And if you go to page 99, the third bullet point on the left-hand column, he says, we've therefore applied overlays to TWUL sensitized forecast to reflect our expectation that the cost of running the business will increase in a SAR. And he's then gone on to explain why it is that he considers the costs of a SAR will likely be more. Now, Mr. Cowlishaw is an undoubted expert in the field. He was, in fact, the special administrator of Bulb, so he has practical first-hand experience of a very similar situation. Yeah. And this is his expert evidence based on his professional opinion as an administrator and as a special administrator as to what he thinks the position would be. Ultimately, when the judge said at 292 of the judgment that these assumptions or forecasts were very pessimistic, in my respect, there was no real basis for that. The judge didn't have evidential material from which he could conclude that these assessments in Mr. Cowlishaw's professional opinion were wrong. So in our submission, ultimately, there wasn't a basis, first of all, for saying that these were very pessimistic. Secondly, the judge made a specific point that he thought there was double counting in relation to the assessment of the likely reaction of suppliers. And if you go to if you go to 103 of the bundle, there's a section credit terms, ransom payments. And what you can see is he's identified some of the risks likely to arise in relation to suppliers. One of those includes the risk of ransom payments, and then the second is accelerated terms. In addition, whilst creditors are likely to seek the payment of historical debts, a number may also request acceleration of their existing credit terms given their perception that TWO is less creditworthy in a SAR. This could create an additional working capital requirement towards the start of a SAR. And then he's applied an overlay in relation to that. Now, the judge's criticism was to say, oh, well, he's double counted some of the potential impacts from suppliers. But in our submission, he hasn't, because if you go to 1673 of the judgment, and this is core 1/3/159, you can see from the first sentence of paragraph 3 of 159 that these aren't mutually exclusive possibilities. The risk that suppliers will accelerate payment terms and demand payment of arrears immediately are both things that may happen, and indeed withdrawal of future services. And what Mr. Cowlishaw has done is effectively acknowledged all of those possibilities and applied an overlay to reflect all of that. And it's not a question of double counting. I mean, he's effectively taken all those possibilities into account and then applied what he thinks is a reasonable overlay to reflect that risk. So we do suggest the judge's criticism of Mr. Cowlishaw as having been somehow guilty of double counting in relation to this is wrong. And then the third point is, if you go in the judgment, staying in the judgment, go to 292.
Yeah.
So, I mean, 292 is the sort of key passage where he dealt with this. I've dealt with the very pessimistic point. And I have to say, I'm not sure why the second part of the first sentence of paragraph 292 is a point against Mr. Cowlishaw. It seems to be a point in his favour as far as and then I've dealt with the double counting point, which is the third sentence, and then this is the second sentence, and then the third sentence is a point about the timing, likely duration of a SAR. He says, moreover, there seems to be no real basis for the assumption that a special administrator would take a year longer to sell the group than the equity raise. And the judge comes back to this then at the start of the next paragraph. I see no reason why a special administrator could not take over the equity raise and complete it in much the same time as the planned company.
Yep.
Now, what the judge in our submission failed to take into account is that Mr. Cowlishaw's evidence about the likely duration of a SAR was based on his view, based on what happened in Rebuttal, that the existing sale process would most likely be required to be relaunched by the administrators, in part due to government and Ofwat requirements over the oversight of the sale process.
Yeah.
And if you go to supplemental bundle 2 at 22, page 822, he makes this point. So SAR duration, Mr. Heiss is of the view a SAR exit could be achieved within 8 months of an appointment rather than the 18 months I've assumed in my initial report. My experience as Special Administrator of Bulb is that a comprehensive M&A process is likely to be a condition of HMG funding, and with a view to delivering a long-term stable solution, HMG and Ofwat are unlikely to be content relying on a pre-SAR process only, over which they've not had full visibility, particularly if the outcome may evolve. And that's a water transfer scheme, which would involve a decision by the Secretary of State. And that's based on his experience in Bulb, where he was Special Administrator. And just to tell you, what happened in Bulb was the existing sale process was restarted when it went into Special Administration. And we have a decision, I don't think I need to take you to it, but we have a decision in relation to legal proceedings involving Bulb, which records that point. It's in Authorities Bundle 4, tab 110, paragraphs 21 and 30 to 31, which I think is a decision of the...
Paragraph, sorry.
Paragraphs 21 and then 30 to...
Tab 110.
Tab 110. So it's, yes, if you want to turn it up, it's a judicial review.
It's the JR, wasn't it?
Yes, it's the JR.
Yeah.
I think it's the, yes, it's the divisional court, that's right.
It's Div Court.
Yeah, and but they don't make a finding on this point, but the relevance of this is it records factually what the position was.
Sorry, give me the paragraph numbers
So it's
again.
paragraph 21. So if you go to paragraph 21, within that, in or around September 2021, Bulb's parent company Simple Energy appointed Lazard to act for and advise it in relation to its attempt to secure a buyer for investor in Bulb's business exercise, given the codename Project Finsbury. And then, if you can go to paragraph 30, Bulb then went into administration, special administration. Paragraph 30, in around February, Bulb acting through the joint administrators and its parent retained Lazard to undertake a further sales process with a view to taking Bulb out of the SAR. And then 31, you can see what they did. So what in fact happened in Bulb is there was a sales process, it went into administration and then they restarted it.
But the sales process was pre-administration, had failed, had come to nothing out of it. That was the point in Bulb. So a year later, one had to start again.
Yes.
But this is slightly different because this is an ongoing process. So if the company goes into SAR tomorrow,
Yeah.
you'd have thought you could pick up with where you are
Well,
already.
I mean, that's not his view. If in the supplementary report, which I showed you at page 822, because his view is that if it goes into special administration, HMG and Ofwat would want the sales process to be restarted because it's a process over which they require supervision and oversight, and ultimately that's because the Secretary of State has to make the decision on the water transfer scheme. So, I mean, it's fairly, in our submission, it's a fairly clear evidence on the point. And then the final point I just wanted to do is there's an allegation then made by Mr. Maynard in his skeleton argument that Mr. Cowlishaw lacked independence and assumed the role of an advocate. In my submission, that's scurrilous.
Well, was that put in cross-examination?
No.
My lord, yes, it was, and it was also put in closing. So
I don't recall him, Mr. Maynard, Mr. Day putting to Mr. Cowlishaw that he'd assumed the role of an advocate. But if I'm wrong about that, I'll be corrected, and no doubt we'll see the reference in the transcript, but I don't recall that. There's no basis for it at all. The judge made no such finding. There's no evidence to assert that. The point seems to be made.
Given that you've been the special administrator of Bulb,
Yeah.
you seem to be an ideally suited person to give expert evidence on the relevant point.
Quite, and the point that seems to be made is Teneo had provided support to the company as well as supplying the expert witness, but A, that's not unusual, and B, it was fully disclosed. Teneo's involvement in assisting with contingency planning, which you might expect, was fully disclosed, and there just isn't a basis for making that sort of allegation against Mr. Cowlishaw, and it really ought to be withdrawn in my submission. So that's the respondent's notice. So I mean, ultimately, as your lordships appreciate, we have the two levels to that. Firstly, we ultimately say the judge was right, but if we are going to revisit that, we have fairly solid points as to why he ought to have concluded that the costs of the SAR were likely to be higher. Then just sort of sweeping up very quickly, there was a point taken about the test the judge should have applied in looking to what the likely outcome of RP2 was going to be. We've dealt with that in the skeleton. The judge applied, by way of analogy, the cases in determining whether a scheme or plan is likely to become effective and whether the court would be acting in vain by sanctioning it. We submit there isn't a difference in test between the different cases. It's not required that there's any particular degree of probability. The test that the cases have used, is there a real prospect or a reasonable prospect? And on the facts, clearly there is a reasonable prospect of RP2 taking place and it having the effect which the judge identified. The other matters, there was some points taken about the burden of proof, and also we should have appointed an independent customer advocate. They weren't pursued orally, so I'm not going to say any more about those. We dealt with them in the skeleton. Unless your lordships have any questions for me, which I haven't dealt with, those are our substantive submissions. I was just going to deal then with the question your lordship asked me before the short adjournment, which is around timing. The group is managing liquidity on a daily basis. It's effectively running on fumes. There is a sort of sliding scale at present. It's not possible to say if we don't get a decision by X date, then it's imminent disaster. The reality is there is a sliding scale, and as each day goes on, it sort of gets slightly more difficult in sort of managing suppliers and so on.
Yeah.
But it's not like if we don't get a decision by 10:30 tomorrow, then we're into SAR. It's much more sort of gradual than that, if I can put it that way.
It's not a cliff edge.
Not at the moment. But each day that goes by, life gets more difficult, frankly, and there will become a point where we will drop off the edge of the cliff. I'm not going to say to your lordships we need a decision by X date. I mean, obviously we would appreciate a decision as quickly as your lordships are able to do that. I mean, if it was towards the start of next week, I think that would be about a decision rather than a judgment. Yeah.
What we were thinking of in broad terms was that we obviously will need to go away and think about all the submissions we've heard. Well, it's been, as I said yesterday, really a 4-day case crammed into 3. I think what we would think of doing, we may decide not to do it, but we would certainly think of doing, is to let the parties know during the course of next week what the result is. But you might not get a judgment for some time after that.
Yes.
Some considerable time after that.
Yes.
But obviously we'll try and get something to you as soon as we could.
I mean,
At least if you have the answer, then everyone will know where they are.
it would be very helpful to have the answer. So, as far as that point, I mean, if it was possible to get a decision as early as possible next week, well, obviously that would help. But I don't think. I mean, your lordships are aware of the position, and thank you very much, my lord.
My lord, if I may, I'm sorry because I seem to have spent my life addressing the cliff edge issue in this case. But if I may just add 2 points. The first point that I would respectfully make, particularly after the pressures that we saw on Mr. Justice Leech, is the most important thing is that your lordships take the time that your lordships need in order to get this right. And I'm going to come on to reasons in just a nanosecond, but I can't emphasise how significant a decision of this court on this matter, which is exploring for the first time a series of issues that relate to restructuring plans, is super important. And that leads me to the second point, which is of course an impossible prediction in the future. In Adler, the Supreme Court gave leave to appeal Now, I have no idea whether my learned friend or anyone else is going to want to apply to the Supreme Court.
Well, we can't control what the Supreme
Of course, my lords, you of course not. But my lords, the point I just wanted to
They
make.
can move quickly when they have to. I mean, in the business interruption insurance case, which I did in the divisional court with Mr. Justice Butcher, the Supreme Court acted, and it went straight to the Supreme Court.
Yeah.
They actually dealt with it very quickly.
My lord, the problem is if your lordships tell the parties what the answer is, but we don't have your lordship's reasoning, we're then put into the difficult position of, do we ask your lordships for a stay when we don't know where we go? And I just want to put that out there because
all those points are well understood by the court. Mr.
Thank you, my lord.
Thank you. I guess we start that time.
For those, I'll aim to be finished by 3:30. I cut some of my material. I'm going to address you on essentially 3 points. I'm going to deal with all of Mr. Maynard's ground one. In summary, I'll be saying that his case fails on the facts and not every step of its analysis. I'll be dealing with ground 1B of the class BAHG. And my job there is not to duplicate Mr. Smith. I want to give my lords an answer that matches exactly the legal theory put by the class BAHG, which is that they are in the money and you should theorise every right that comes out of a restructuring plan as a benefit that is part of the restructuring surplus, and ask whether any differential treatment is justified. I think it's important you have that answer.
Yeah.
Thirdly, I'll be addressing TWL. I'll be addressing grounds 2 to 4. I'm not duplicating Mr. Smith. My main point on the law there is that TWL has misread the horizontal comparator. As we say in our skeleton argument, what it's done is it's untethered it for a relative inquiry between creditors. And that's how it ends up with the question of saying, has this particular creditor given enough? So it's a flawed legal theory. And one goes on from that to see that its case on the facts is, I must say, it's not really a case that it can put, and I'll take my lords through the way it put its case at trial. And in view of that, I'll do it briefly. It's not right that it should criticise the judgment in the way that it does, given how it put its case before the judge. So that introduction, can I turn on Mr. Maynard's skeleton argument on appeal, because I wish to highlight certain points that I'll come back to at the very end of my submissions. So paragraph 1, can I ask you to note the way he phrases the questions for the court? It's about how best to rescue Thames Water as a going concern. He continues, is the plan or the relevant alternative the best bridge to a substantive restructuring? And it's the phrase the best that I ask my lords to have in mind. Because although my points are going to be phrased independently, they will accumulate to one large point, which is that we don't have an exaggerated view of justiciability on our side. We would accept everything, Mr. Smith, and we said it in writing already, about what constitutes a blot in terms of, for example, a plan that would cause a water undertaker to cease to function as a water undertaker. That would be an unlawful plan. We also don't have an exaggerated view of justiciability in the sense that the Secretary of State is a public body. He's subject to statutory duties and the statutory powers. He is subject and amenable to the remedies and norms of the administrative court. The logical endpoint of Mr. Day's submissions is he's critical of Ofwat and the Secretary of State for allowing this plan to continue and not putting the company into SAR. Ofwat's taken the position that it's a private law restructuring. We have had a view from the Secretary of State. It's in Mr. Maynard's evidence. In my written submissions, I'm critical of Mr. Maynard's evidence in that he doesn't draw attention to the answer given by the Secretary of State to a written question about this company, which says much in line with Ofwat. So the two bodies that are charged under section 2.1, and that's the section of the Water Industry Act my lords were not taken to in deciding how best, and that's why I pick up on those words in the introduction to Mr. Maynard's skeleton, the two bodies that are charged with administering the special administration scheme and how best to decide it, have decided not to do so. And that's why we cite the market case. And just to finish on this point, before I go into the detail, the market case is a tort case. That's well understood. But the reasoning of it is instructive. The reasoning of it hasn't been overruled in United Utilities. It's been applied in the negative to distinguish it. The essential point in that case is that you had an existing sewerage system, and the tort of nuisance as between two landowners wouldn't allow a balancing of whether or not to make an enforcement order. It's only if an enforcement order were made by the director, now Ofwat, that there could be a private right of action to enforce it. So if one allowed simple access to the tort of nuisance to require remediation or damages, one is effectively on the side of the court, which is not equipped to make those decisions, effectively making a decision as to capital expenditure. Now, that's the ratio of the market. That's been approved in the United Utilities and distinguished in the different legislation that applies to a discharge of untreated sewage into a canal. This isn't a tort case, but that aspect of the market alerts us to, we have to look at the Water Industry Act, its framework, how it allocates duties and responsibilities. And my learned friend Mr. Day's case works in two ways. He says that there is this thing called Part 26A, which is about binding minority creditors. He has two gateways to bring into Part 26A, the public law, public interest aspect that he asks this court to adjudicate on the basis of. One is an extended meaning of the horizontal comparator. He's wrong in that respect, and I'll address you on that. The other is the definition of blot. And at blot, he's alighted on the decision in Halcrow, and he likes the decision because Mr. Justice Voss says it's a concept without inherent meaning. It's a very broad concept. So that's his gateway. He says it's a wide concept, so I can fit everything into it. But if you accept it as broad as that, the question for this court, which is the company's court, is by what standard does it adjudicate? Because it's a concept with no inherent meaning, which is how he puts it, that's not the right test for blot. Now, I've got a point on that, but assume it is. It's asking the company's court simply to apply its statutory discretion, and it's doing it to address the questions as he frames them in question 1, which is the inquiry of how best to rescue and recapitalise Thames Water. And when I take you through the Water Industry Act, I will be focusing on section 2.1 and showing you that that is within the domain of the Secretary of State. It's within the domain of the Secretary of State with respect to the relevant provisions as defined, which includes sections 23 and 24. So with a fair wind from market, what I'm essentially saying to you is, although it's put as a fig leaf that all this court has to decide is whether or not to allow appeal against sanction, in substance what it's being asked to do from the way Mr. Day puts his questions for the court is to exercise a discretion which is allocated elsewhere under the statute. And in my respectful submission, that does fall within the points about justiciability that Lord Hoffman warned against in market. So with that overview, can I go to the grinding detail? In paragraphs 8 to 14 of our skeleton argument, we address Part 26A of the Companies Act. Many of these points have been addressed in discussion already, so I'll go through them briefly. The first is that Part 26A and the case law under it, including by Lord Sir Nicholas Patten's decision in the Lehman Scheme No. 1 case at paragraph 65, for the transcript, Authorities Bundle 44795, it's about putting a compromise or arrangement to creditors. My Lord Sir Nicholas Patten said that it's about the rights of creditors only, because the issue in that case was whether you could deal with beneficial interests, and it was only the in personam rights of creditors. Now, I springboard from that to say the essential point about Part 26A, it's about binding the minority. My Lord, Justice Zacaroli put the point in argument, what would be the case if there were unanimity among creditors as to the plan? The answer is primitive contract, and Mr. Maynard is a stranger to the contract. The court may well have a generous standing rules under a scheme, but it wouldn't admit any submissions by him as to the meaning of a party's contract, let alone its enforceability. I'll come back to that point when we deal with the BAT case. And just to flag where I'm going, in the BAT case, there's two aspects. One is the standing aspect, the other is the decision on blot. And when we looked at the reasoning of Lord Justice Newberg in that case, it's very instructive that the point I've just made, although standing was allowed, comes back into the question of why it's not a blot. That's the first point. The second point is that Part 26A has as its purpose under Section 901C to mitigate or resolve the company's financial difficulties. The ability of the directors to put a proposal is an exercise of their power of management. No one has said at trial, at any point in cross-examination or in submissions, that this plan had been put and proposed in breach of duty. The directors are exercising their power of management properly. I've got about 10 transcript references and bundle references to all the other parties' submissions where this point wasn't made, but they came close to it. In the interest of time, I'm not going to do it, and I'll move on. The third point is that every test the court has come up with under Part 26A and Part 26 is focused on the rights of creditors. I'll ignore members for present purposes, but it's focused on those affected by the scheme. Start with the rationality test. This is a test of the honest, intelligent, reasonable creditor. The way a scheme works and the way an assenting class non-cramdown situation under Part 26A works is that there's a proposal, there's a vote on it. If there's a representative majority, the court puts itself in the position of the honest, intelligent, reasonable creditor and is slow to differ from the majority assessment of their interests. And the slow to differ is important because that's a direction as to how the court should exercise its discretion. So the rationality test is creditor focused. Then there's the vertical comparator test, which compares the outcome under the scheme or plan with that under the relevant alternative. That compares the interests of the creditor under the plan versus the relevant alternative. It's primarily financial. There's a statutory instantiation of that in the no worse off test. That's Adler paragraph 152. Lord Justice Snowden expresses it as a codification of the vertical comparator. We then move to the horizontal comparator. We've read all these points before, so I'll give you them briefly. At paragraph 149, Lord Justice Snowden defines the horizontal comparator. If my lords want to read alongside me, it's at page 2569 of the bundle. He says, the horizontal comparison compares the position of the class in question with the position of other creditors. That's the key point, because it's where TWL goes wrong, and it's where Mr. Maynard goes wrong. It's a relative inquiry as to the position of those affected by the plan. It is nothing more, nothing less. We haven't turned up, I think. We've looked at paragraph 158 of Adler, where, if we look right up on the screen, it's Authorities Bundle tab 118, page 2569.
Paragraph?
158.
Okay.
It's the approval by Lord Justice Snowden of my Lord Justice Zacaroli's judgment in the House case.
Yeah.
And he approves paragraphs 29 to 31 of that judgment. And in that judgment, my Lord Justice Zacaroli says, the court is required to see whether the plan provides for differences in the treatment of creditors inter se, and if so, whether the differences are justified. In doing so, a relevant reference point, he puts it no higher than that, a relevant reference point, is the treatment of creditors in the relevant alternative. Paragraph 159, Lord Justice Stone says he agrees with Mr. Justice Trow and Mr. Justice Zacaroli. I won't read the paragraph. The paragraph of the judgment we haven't looked at is at paragraph 180. 180. If we can just scroll down to that. If I can just ask you to read that paragraph to yourself. And so he approves, in particular, Mr. Justice Zacaroli's statement 196 of New Look, which is that in considering whether the allocation of assets is fair, the court is necessarily required to consider whether a different allocation would have been possible. And Lord Justice Oden affirms that at the end of paragraph 180 in relation to part 26A. Now that's why it must be the case that a relevant reference point is only a relevant reference point, because you can look at it either from the perspective of the relevant alternative or how else the rights might have been reconfigured under a different plan. The ultimate question is whether the difference is justified, whether there's good reason and proper justification. That's the test. Now what I get from that in relation to Mr. Day, it's clear, putting all of those principles together, that it's a relative inquiry focused on the justification for the differential treatment of creditors. What that means as regards Mr. Maynard's submission, if you go to his skeleton argument, which is at tab 16 of the core bundle, and look at paragraphs 22 to 28, his first gateway is entirely wrong.
Sorry, the paragraphs again?
22 to 28. It's on page 388 of the bundle. It's under the heading Adler, the public interest should be given particular weight. This is his first gateway, and I won't go through all of those paragraphs now, but the argument made in 22 to 28 is based, as the subheading suggests, on Adler and the horizontal comparator. It's put most clearly at paragraph 26. Now, the logic of paragraph 26 is that because there is this thing called the horizontal comparator, and because in this case the relevant alternative is a SAR, you put the two together in some sort of car crash, and you end up with the court taking into account public interest grounds through the gateway of the relevant comparator. The legal part of the analysis is a misuse of the horizontal comparator, and I've given you the reasons why I say it's wrong. I'll come on in a moment to what I say is a logical flaw in the analysis, which is the read across from a SAR to part 26. Before I move on this point, I need to deal with the second gateway, which is blot. And on this point, my first point is that our case shouldn't be taken to be an exaggerated case. Like my learned friend Mr. Smith, we accept that a blot would involve a breach of a water undertaker's duty. So if a consequential return of the plan would occasion that, that would be a blot. I would even go further than this. I would say that not only would Ofwat and the Secretary of State have standing to intervene on a plan and object to its sanction on that ground, I would accept that others might be able to do so. Under the rules on standing, others might be able to say that they have an interest in doing this. If the Secretary of State for some reason went nap and a water undertaker were to put itself in breach of duty by a plan, others affected could come to court and could be accorded standing to object to that blot on the plan. None of that, however, all of which I'm happy to accept, involves any concession as to justiciability on the wider grounds put by Mr. Day, because a blot so framed involves a bright line by reference to legal standards to which the court can adjudicate. Because if a blot is a breach of a water undertaker's duty, that duty is defined by statute. The court can look to it. And Mr. Day was entirely right to say in his opening that when the court's adjudicating on a performance ground, if one applies under section 24 by the Secretary of State because the undertaker is in breach, and that's the reason to go to SAR, it's entirely right to say that that's something on which the court can and does adjudicate. Where he goes wrong is the point I made in my introduction, which I'll come back to. But just on the question of blot, You asked for particular submission on this, my lord, from Mr. Day, and I thought it would be instructive for the court to see where blot comes from. It actually comes from a decision of this court in 1893, and it's literally one line, and that's where the fountainhead it is. I've put into the authority fund, and it should be ready to hand out the decision in equitable life.
Yes,
Makes
we've got
the point.
It's on the-
You got it.
on our desk, I think. I've got it.
So this is the equitable life scheme of arrangement.
Yeah.
It's a judgment by Mr. Justice Lloyd. There's two pertinent paragraphs. If one goes to page 343
Yeah.
and reads paragraph 67
Okay.
and the quoted part of the text.
Let's read that. Yeah.
That's it. That's the origin of blot. It's something Lord Justice Lindsay said in one judgment in one line.
Yeah.
The second reference in this judgment is the argument as to what he meant. That's at paragraph 96 at 350. Because as has happened in this case, the objectors had seized upon the concept of blot, and they tried to stuff quite a lot into it.
Yeah.
And you've got Mr. Justice Lloyd's view, as he then was, as to what it means at paragraph 96. Later cases, which I'll go to, develop this a little, but the core meaning, as explained in that case, is it is something, a fault within or as a consequence of the scheme. It's in the nature of an oversight or miscarriage. I don't know if you've had the pleasure of counting. There are 45 scheme and plan cases in the authorities manual dealing with the question of blot. I'm not going to go through all of them. What's instructive is that only 2 have actually held there was a blot.
Yeah.
And the next point from that is there's always something odd about when a judge says, well, what do you mean by blot? And the answer is, my lord, there's so few cases that have actually said what a blot is. There's loads of them that say what a blot isn't, but there's very few that say what. The cases that have upheld the blot, and we'll look at both of those very briefly. There's Metal Box Group, which we'll look at in the course of looking at VAT, and there's Naismith. Metal Box Group is a decision of Mr. Justice Harman. I'll just give you the reference to it. It's in the VAT decision, Authorities Bundle, tab 30, page 492 to 93. And in that case, it's a shareholder scheme. And Mr. Justice Harman accepted, and he required the scheme to be changed because the deal was done before he gave judgment, that the terms of the arrangement would cause a breach of certain warrant contracts. Because if you're going to transfer shares and you do a deal with shares, if someone has options in the form of warrants over the shares, you can occasion a breach of that contract. And he accepted that that was a blot. That's one example of blot. The other example of blot is Naismith. That's a more recent case. And again, I think I can just give you the references. This is AB 108 2562. It's a judgment of Mr. Justice Leech. If you want to look it up.
Yeah, let's have a quick look at that.
Sorry, where is it?
Tab 108.
108.
This is Mr. Justice Leech.
2562. It's Mr. Justice Leech and the Naismith decision. The pertinent, well, if we read the pertinent parts, if one goes to the holding, it's holding number 7 on page 2184.
Yeah.
That will give you the relevant decision. And then the issue is at paragraph 5 on 2187. And the issue in that case, it's a scheme that was cramming down HMRC as a secondary preferential creditor. And the efficacy of the scheme was dependent on HMRC entering into a time to pay arrangement in order for the scheme to go ahead. And HMRC, represented by Ms. Cook, I recall, essentially said no, and therefore the arrangement didn't work. And that's what the judge finds at page 2313, paragraphs 129 to 130.
Yep.
So those are the two examples of a blot that we actually have in the bundle. I've had a look for others overnight to see what I put in and haven't found much. Can we look at the two decisions Mr. Day relies on in particular? One is BAT. This is Authorities Bundle 30, and it's page 498 to 499. The part I'm going to read is not the standing decision, but Mr. Justice Newbody's decision on whether there was a blot. And so this should be under his heading conclusions. And you'll recall that this was a hive down transaction. So it's a distribution in specie of essentially a company's undertaking below. And the objectors were claimants in US class action litigation concerning tobacco. And their objection was essentially that if you do this, they said, you will impact our ability to recover on our judgment when we win. Now, you might think the answer to their case would be, well, you've got no interest under a scheme of arrangement. You should bring an action under Section 43 of the Insolvency Act if you think someone is putting assets beyond the reach of creditors. Be that as it may, they were given standing and their objections were entertained. The judge gave several reasons specific to the facts of that case. Can I ask you to pay attention to reasons 1, 3, 4 and 6? If I make some brief submissions on the basis of those points, my lords. As to the first point, having allowed standing and therefore not adhered to the concept of a scheme as a domestic matter between, in that case, its members, his first is that the primary concern of a scheme of arrangement, under that case in Section 45, is as between the company and the members. So that's why I ask others about it and say, well, you can't read too much into the standing cases. Focus on the content of what's a blot. In terms of deciding whether there's a blot in this case, the judge's first point is this is primarily between the members and doesn't affect you, and that's true of this case also. The third point picks up on my Lord Judge Zacaroli's question yesterday, which is, well, what if there was unanimity amongst the creditors? Because, in principle, one doesn't need a scheme to do a restructuring agreement, in principle it can be done without a mechanism to bind the minority. And that's the third point Mr. Justice Newberger picks up with this. One doesn't need a scheme to do, in that case, a hive down. In this case it did, but the fact that we don't need to do it is something one accounts for in assessing whether there's a blot. The fourth point, in that case, there was no suggestion the transaction was aimed at denying recovery to the litigation creditors. The analogue in this case is this plan is not objected to by Ofwat or the Secretary of State. There is nothing to suggest this plan involves a wrong, if I can use that summary expression. The sixth point is to the view of the directors. In this case, it's not suggested the directors are acting in breach of duty in seeking to avoid a SAR. My lords, those are the two reasons why the legal case is flawed on the part of Mr. Maynard. You can't use the concept of either the horizontal comparator or blot to bring in public law considerations if you would wish to. As to the factual answers, I'll just state these because I rely on the analysis of the numbers and value undertaken by Mr. Smith. The first point is this. Mr. Day's submission accepted, when asked by my Lord Justice Zacaroli, that the nub of his case is that the super senior funding is too expensive. That's one way he put his case. There's a blot because it's too expensive. The answer, and I'll come back with a couple of figures of my own when dealing with TWL, is there's no evidence to justify that conclusion. If it's the case that it's a blot because the funding is off market to such a degree that there's a blot, so the directors have acted in breach of duty in agreeing it, or there's been some extortion on the part of my clients to compel it, some sort of pressure or undue influence, there's no evidence to justify that at all. The second way the case was put by Mr. Maynard is that there's a blot because a SAR is a better rescue and recapitalisation method. That's the broadest way he puts his case. Now I'll come on to the legal answer about justiciability, which I've given my lords in outline. But the factual answer is the answer given by the judge at paragraphs 303 to 304 of the judgment. This is core bundle 3. 240 to 242. We've read these paragraphs already. It's where he says that the costs of the exercise will ultimately fall on my clients. So those are the two factual answers. But as I say, I think that there's a legal flaw, which means one doesn't even get to the factual answers. But I would urge you in considering the matter to actually put it the other way around. What's the factual case Mr. Maynard advances to support the blot? It's met for the reasons Mr. Smith's given. That's the first heading on this topic. The second heading is at paragraphs 15 to 19 of our skeleton argument. And this is what I refer to as the illogical read across from a SAR to part 26. Mr. Maynard treats it as self-evident that because the relevant comparator is a SAR, that is justification for bringing in all that a SAR entails into the assessment of the plan at sanction. Our position is that that's illogical and counterintuitive. Can I deal with the way it was first put by Mr. Maynard? Because there has been a shift in his case. The way he first put the case and put it at trial is he was reading across what he called the SAR statutory objective. So he focused on the rescue purpose or the transfer purpose under a SAR. I'll then come to his expanded case, which focuses on section 2 and all the duties in respect of the public interest. We'll turn to the Water Industry Act in a moment. I see my lord looks tired. I have the same
sorry,
feeling.
I shouldn't have done that.
No, I have the same feeling every time I turn up the Water Industry Act. The 4 points are
I'm not bored by your submissions at all. They're very interesting.
The 4 points are these, before we go into the detail. Section 23.2 and 23.2b define the statutory objective, and by that definition it applies only when there is a SAR. That's the first point.
Hmm.
The second point, the statutory objective is assessed by the insolvency practitioner in the SAR. It's never assessed by the court. It's what the administrator thinks. He's left to the manner of how to pursue it and which of the two to pursue. The third point is the one I learned from Smith, Mr. Smith has emphasised, that there isn't in fact a subordination of creditors under the legislation. It says to protect and balance, that's the task. The fourth point is the generosity of the discretion. The word is thinks, so it's a rationality review. Now, we haven't looked in detail at this, but if we can just canter through the legislation, it's the Authorities Bundle, tab 4, page 78.
Yeah. This is section 23.
23.1. You've read it before. The words on which I emphasise and rely are during the period for which the order is in force. Not before, not after.
Yeah.
So if one accepts that the STAR statutory objective applies in the currency of the order, and one accepts that there's no breach of duty in promoting a plan to avoid a SAR, it is illogical to read across the STAR statutory objective to Part 26. The next point is going on to section 2b. This is the purpose. And the words I wish to emphasise are in letter B, they're the words only and thinks. Because it's the transfer purpose Mr. Day relies on to get into the world of efficiency. Because his submission is that because the administrator can pivot to a transfer, if he thinks it would produce a more effective performance of functions, that's his argument for subordination. The point I'm emphasising is that that's in the control of the administrator and within his ambit. The next point is at 23.2d. The administrator, if he thinks it serves a purpose, can promote a scheme of arrangement or a restructuring plan. Now, this leads to a fifth point. How is a restructuring plan modified in a SAR? The answer is the one we've given in our skeleton argument, paragraphs 18.3 and 18.4. I've given you the references to the legislation. It's modified so that only a special administrator can propose a plan, and it's modified to require notice to Ofwat and the Secretary of State. What's significant is that outside of a SAR scenario, Part 26A is not modified at all. And so putting the two aspects together, SAR, a plan outside a SAR and a plan within a SAR, within a SAR, Part 26 is only modified in the way as I've said. It is a tool to be used to bind a minority. It is only that, even within a SAR. It's obviously proposed by an administrator and to be notified to Ofwat, he must use that tool in accordance with his statutory duties. But what's significant is the other point. It's not modified outside the SAR scenario under the Water Industry Act legislation. It's left as a purely private law restructuring tool. That's a logical reading of that legislation in my submission. That leads me, my lords, to my...
So is it, sorry, just so I understand that point. If the point you make about subsection 2D is that it's the special administrator who proposes the Part 26A
Yes. And the only
plan
modification...
rather than anybody else. And that there's nothing in this statute that somehow modifies Part 26A itself.
Outside of the SAR.
Outside the SAR. In other words, if he does that, then the rest of Part 26A follows in the same way as it would in any other Part 26A.
Exactly. Let me put it another way. Had the draftsman of the Water Industry Act and the associated SAR legislation intended for this court, when dealing with a plan to avoid a SAR, i.e. outside a SAR scenario, to have intended it to approach the exercise of its discretion or indeed any matter in any way from any other plan or scheme, he could have said so. The primary legislation provides it. There's been no specification in the primary legislation or the subordinate legislation made under it. So the logical deduction is what put before this court on appeal is a purely private law restructuring aimed at avoiding a SAR. That takes me to my third point, which is that Mr. Maynard has actually wrongly identified the public interest. Now, he's explicit about this. If we can go to our skeleton argument at tabs, paragraphs 4 and 5. We set out an extract from Mr. Maynard's skeleton argument at trial. This is how he put it to the judge. It's under the Maynard public policy factors. If you can just read that and remind yourself.
So which paragraph?
Paragraphs 4 and 5 of our skeleton argument on this appeal.
Yep.
And in those paragraphs, we set out
Yeah. Yes.
and if you then go to Mr. Maynard's skeleton argument on this appeal, at page 385 of the full manual, I've taken you to paragraph 1 already, and the way he uses the word best. But can I ask you to note the underlined words in paragraph 15 and the last sentence of paragraph 15?
Yeah.
And this is what Mr. Maynard says is the public interest. And my point is he's misdiagnosed it. The judge accepted, because of the way it was put to him below by Mr. Maynard, it's about the continuity of uninterrupted supply. That's a public interest.
Yeah.
The judge has held at page paragraphs 285 and 305 of the judgment, actually accepting Mr. Maynard's submissions. The point is the case has shifted a little on appeal to a different public interest. The reason it's had to shift is because of paragraph 6 of our respondents' notice. We'd said, well, if that's the public interest, there's an obvious non sequitur in your case, because there's nothing in this plan which jeopardises the uninterrupted continuity of supply. So that's a flaw in the case as was put at trial, and it doesn't seem that way of putting it's now being pursued. Just to finish on this sub-point before moving on, the judge was undoubtedly right to diagnose the public interest as the continuity of uninterrupted supply. And you can see that if one steps back and asks, what is the mischief under the unmodified insolvency law that the Water Industry Act intends to solve for? If there was no Water Industry Act, but there was a privatised water company, it would be a general company regulated by the Insolvency Act of 1986. If it went into administration, its administrator would look to sell its good assets for the best price reasonably available. That would be what his duty required. If he couldn't rescue the company, he's in that world of sale. His duty is owed to the interest of creditors as a whole. If an asset is burdensome and he can't sell it, he can then go into liquidation and he can disclaim it, so he can abandon it. That's the detriment to the continuity of supply that exists for a water utility under the unmodified insolvency law. The Water Industry Act solves for that. We've explained this in paragraph 36 of our skeleton argument. It's also explained in the explanatory statement to the water regulations at paragraph 7.1 and the guidance, which is cited in the judgment at paragraph 56. Now, if I can move on a little to section 2 and my next heading, which is the respective roles of the court and the Secretary of State under aside.
Yeah.
Now, for my Lord's note, this is dealt with in our skeleton argument of paragraphs 20 to 32. Section 2 is in the authorities bundle, tab 4, page 57.
Yeah.
You were taken to part of this by Mr. Day, but you were not taken to all of it. The most material part that you were not taken to is subsection 1. Can I ask you to read that?
Yeah.
So that's the assignment by Parliament of the powers and duties to the Secretary of State. And there's a term for relevant provisions, that's defined in subsection 6. And if one scrolls down to page 60, you can see that definition. And the relevant provisions of Roman 1 includes part 2 of the Act. Part 2 of the Act includes sections 23 and 24, which are the basis for grounds for a special administration application. So with that in mind, if we then read quickly the remainder of section 2, I'll just, in the time available, point out the main points. It's the Secretary of State, or the authority, that has to decide when and how to exercise and perform the powers and duties conferred by the relevant provisions. And then there's a specification in the subsections 2A and onwards of objectives that are to be considered. So there's 2A is the consumer objective, 2B is the proper performance of functions, and there is one concerning finance. Let me just, it's 2A sub C.
Yeah.
It's
properly
able, in particular, by securing reasonable returns on capital, to finance the proper carrying out of those functions. So if I just sketch a little vignette, if you imagine the Secretary of State is in the corner of the room with some government lawyers, and they'll be saying, look, it's your duty and responsibility to exercise the relevant provisions with respect to these factors. Those include the special administration regime. You're going to consider the consumer objective, the functions of the water undertaker, and you're going to consider the finance objective, whether it's able to finance its functions. If you don't think it can finance its functions, you have a duty, a statutory duty, to consider these factors and to act as you see fit. And the reason I emphasise it best in my opening is because that's the word used in paragraph 2A. The Secretary of State, or as the case may be, the authority, shall exercise and perform the powers and duties mentioned in subsection 1, the relevant provisions, in a manner in which he or it considers best calculated. And it's transparent where I'm going with this. The way Mr. Day has phrased the questions asks the court to undertake the assessment that Parliament has allocated to the Secretary of State. The language is so strikingly similar. The only paper, and so this is a cigarette paper that you can put between them, is that what's before this court is an appeal, not an application for special administration. Just give me a moment, others. Now, Mr. Maynard has an answer to this, he says, in his skeleton argument. he disputes this at paragraph 13 of his skeleton argument. And tab 16 of the core bundle, you can see the argument. It's at page 385. So maybe just
No,
no, it's the right reference.
389
It's 385, paragraph 13.
and 30.
13.
Okay.
And his point is, he says that a creditor can initiate a special administration, and he cites section 25 of the Water Industry Act. That's wrong in law,
Yeah.
because if we go to section 25, which is at page 85 of the authority manual. Section 25 isn't a power of the creditor to initiate a special administration. It's a prohibition on the court on making a winding up order. And it instead is an obligation of the court, when faced with a winding up petition, to make a special administration order.
Yeah.
Only if it thinks appropriate. Isn't it?
Only if the court thinks it's appropriate to make a winding up. So if the court thinks the grounds of a winding up are satisfied, it can't make a winding up order, it has to make a special administration order.
But under section 24, the special administration, an application for a special administration can only be made by the Secretary of State or Ofwat.
And the legislation has been fixed, and this is the point we go on to make in our skeleton argument. The Water Industry Special Measures Act 2025 fixes a gap in the legislation, because initially a petition didn't have to be notified to the Secretary of State. So section 25 is being amended so that if there's a creditor petition that comes before the court can't now make an order on it for 14 days and must notify the Secretary of State. Now, that's dealt with in the policy statement to that part of the new legislation. That's in the authorities bundle, tab 19, page 364 to 365.
Okay. Yeah.
So it's reading from the bottom of the page, really over to the next two paragraphs.
Just what does it start?
It says currently, in the event that the water company becomes insolvent, that's at the bottom of page 365 going over to 366. Oh, sorry, bottom of page 364 going over to 365.
What's my number? But I've got it. So have I got this right? A creditor can issue a winding up petition, the consequence of which would be the making of a SAR order.
Previously under section 25, that's right. The creditor can issue a winding up petition only on the insolvency ground. If the court's satisfied it cannot make a winding up order, it must initiate a SAR.
Yep.
What I've just shown you is a note to the legislation that changes section 25 as you've read, which says that when a winding up petition comes before the court can't make an order on it because it's got to give notice and 14 days notice for the Secretary of State and to Ofwat. And what's explained in the explanatory note that you've read is that's because the making of a SAR involves the assessment of the public interest, and therefore the Secretary of State and Ofwat should be involved. That's what's explained in the note.
Yeah.
So it's wrong, as Mr. Day puts it in the skeleton argument, that a creditor can initiate a SAR in the sense of they have a right to apply. What they can do is they can present a petition for a different remedy. There's a prohibition on that remedy, and there's a notification regime that brings in the relevant authorities who are to consider the public interest.
And at that point, the Secretary of State or Ofwat
They'll
could
make submissions
make
to
an
the court
application
as-
for a SAR.
And they'll make submissions in response.
Well, they make submissions to start with.
So I may be being a bit slow, but you showed us 25. 25 on its face says that if the court can't make a winding up order, but if it was satisfied that it would have been appropriate to make a winding up order if the company was not didn't hold a license, it shall make a special administration order.
So I've shown you the unmodified version of section 25.
You've shown us some notes, but is there an amended version of 25 we should be looking at?
Yes.
Yeah,
I'm just
it's
going
to
to
previous tab 18, isn't it?
I think so. Tab 18, page 352.
Section 25. It's a new subsection 2.
Yes, so the court cannot exercise
The
its
court
power.
may not exercise its powers on the petition unless.
Which tab? I haven't got which tab.
It's tab
18.
18, page 352.
Well, no, it isn't. Right. Does anyone have the electronic version of the authorities bundle to help me with it?
I have the electronic version. It's page 352.
Electronic version 352.
Yes.
Never mind, I can find it afterwards, I'm sure.
It's the trouble is it does sort of give the impression that on a winding up petition, the court can then, I mean, provided that the Secretary of State and Ofwat have been notified, the court can go on and make a SAR, even though the application is not being made by the Secretary of State or Ofwat.
I'm accepting of.
If they just sort of say, well, that sounds like a good idea, let's do that then.
In a sense, that's my point.
Yeah.
What's put by Mr. Day is exaggerated. He's suggesting that a creditor
There's a sort of
has
general
a free
power to-
hand
yeah.
to
No, I follow.
initiate a SAR.
I follow.
My point is, and as explained in the explanatory note, it's been hemmed in safeguards, as the parliamentary draft explains, to ensure the public interest is considered by the parties that should consider it. Now, I'm conscious of the time, so I just want to move on. I just want to give my lords some references to the other statutory scheme which we've referred to, which is the energy supply scheme. And in particular, my lord Justice Zacaroli's decision in Bath. It's in the Authorities Bundle 103, page 2044. The paragraphs I'd invite you to read, I don't have time to go through them, are 60 to 62 and 94 to 113.
Sorry, which tab is it?
103.
103.
Yes. There were two issues in those paragraphs. The first is my lord was rejecting a submission that the court was required to assess the likelihood of the transfer purpose being fulfilled. And his reason for rejecting that is essentially the diminished role of the court in relation to the transfer scheme. The second part, paragraphs 94 to 113, he rejected the submission that he should not exercise his discretion to set the date of the transfer pending the outcome of the judicial review proceedings. And paragraph 110, he says, those are not considerations for the administrators or for the company's court. They are matters likely within a judicial review challenge and thus likely matters for the administrative court. The point of drawing my lord's attention to that is that the role of the Secretary of State is defined in relation to the water industry special administration scheme, and the role of the court is to some extent diminished. There's no jurisdictional purpose under the SAR regime. The court isn't required to be satisfied that the purpose of the SAR is likely to be satisfied. That's the point that I want to draw attention to. The next point is we deal with in writing at paragraphs 28 to 29 of our skeleton argument. I can only give you the reference at the moment. In that paragraph, we draw attention to paragraph 83 of Mr. Maynard's evidence at trial, where he says simply that the Secretary of State is carefully monitoring the situation. What we set out in full in those paragraphs is a letter from the Secretary of State in answer to a written question from a Member of Parliament concerning this company.
Yeah.
And ask you to draw that and take it into account. And finally, to bring to an end my submissions on Mr. Maynard, we come back to the public interest ground and this issue of non-justiciability. It's dealt with at paragraphs 36 to 41 of our skeleton argument. The main authority we rely on is the Shergill case that we set out the relevant parts. That sets out the test for justiciability. It's at Authorities Bundle 52, 1051. And it's paragraph 40, where Lord Newberger expresses his disagreement with Lord Justice Mummery's decision in this court, and he explains the speech of Lord Wilberforce in the Butts case. And it's not justiciable if something is political and there are no standards by which the court can adjudicate. It's instructed by laws, when you've got a moment, to read on to paragraph 43, because obviously the concept of justiciability and non-justiciability shouldn't be exaggerated. Things that aren't justiciable in the sphere of private law can be justiciable in the scope of public law. And that's the point Lord Newberger makes at paragraph 43. And that's why I said at the start that the logical endpoint of Mr. Maynard's case is actually an application for a mandatory order against the Secretary of State for not commencing a SAR. And the crucial point about judicial review is that it's a review. The court is never itself the decision maker. All public law norms respect that aspect. And yet, from the way Mr. Maynard puts his questions, he is asking you to trespass onto the domain of the Secretary of State. That's my essential point. I've explained Markic.
Well, that's the point that I think I made yesterday.
And
remedy being a JR remedy as opposed to.
And we adopt that point. I must say, Manuel, when you raised it, I couldn't tell whether it was a help or a hindrance.
It was intended to be. I was simply making the point that what the failure to apply for a SAR, if it's justiciable at all, has to be justiciable via judicial review. I mean, whether it is or not, we needn't debate for the present.
That's the point.
But that's the point.
That's my point. Those are my submissions on Mr. Maynard. I'm conscious of the time, but I've got very little left to do.
Okay.
Moving on to Ground B's appeal, I'm dealing with Ground 1B. That's in the core bundle, tab 6, page 266. And the particular point I'm going to deal with is their complaint about the non-participating A's and the role they play in the JRC and the supporting LUA. As I explained, I'm going to do so on the basis that they're in the money. There's one point I'll make on out of the money, but for the most part, assume they're in the money and assume they're right to theorise everything that comes out of the plan as a restructuring surplus. The question is there good reason and proper justification? The answer is written and fully in paragraph 49 of our skeleton argument. Before I develop the argument there, it would be useful to have it open so we can go back to it. There are two preliminary points I should do. My Lord Justice Zacaroli asked what is meant by a veto right. He asked that question of Mr. Phillips. Can I give, if I may, a clearer answer to what's meant by the veto right? There are two things they mean. One is the release of funds after June 2025. That's the holding the purse strings point. The other point is effectively the launch of RP2. And just so you have the references, these are all in the judgment. Paragraphs 22 to 27 of the judgment set out the terms of the security and trustee, the STID, that are the entrenched rights of the Class A creditors that the Class Bs do not have. Paragraphs 200 and 203 hold the meaning of those terms as a matter of construction, against which there's been no appeal. Paragraphs 204 to 206 explain the event of default carve-out and how it works with the lock-up. The point about a veto right is simply this. Under the pre-planned terms, an insolvency proceeding is an event of default. What the plan does is it pre-authorises the launch of RP2 such that it's not an event of default to do that if there's a lock-up agreement for it and the limbs of the lock-up agreement are satisfied. That's the veto point. And the second preliminary point is the Bs have been sphinx-like about what they say that the vice is, because is it the presence of a non-participating A limb, or is it the absence of an equivalent B limb? And the point does matter, because if you just take away the non-participating A limb, what are you left with? Mr. Thomas Watson accepted at trial that it was standard practice for there to be a lockup for RP2. So if you take away, so if no one has a say under the definitions, there's still going to be the hard practice of a lockup agreement, as well as the hard fact that you have to vote on an RP by the majorities. And that's really when Mr. Justice Trower, when he first saw this, looked at it and said, well, what does it add? That's part of the judge's essential conclusion. The other way of looking at it is you have to add in a non-participating B limb to the supported LUA definition, and that really is objectionable. And that, in my submission, is actually what this case is about. The Bs are, this is the out of the money point, they have been held to be out of the money. What they want to do is to have an insertion into the supported LUA definition such that you cannot launch RP2 without them being locked up to it. That actually gives them a veto right over RP2. If they are out of the money, that is completely unacceptable. But assuming that they're, if they're in the, if they're out of the money, that is completely unacceptable. Yeah. If they're in the money, that's the answer we largely give in paragraph 49 of our skeleton argument. And the point is this. There are three things that happened here. One is the STID proposal in October to release 400 million from the whole business securitization. Okay. That allowed the business to trade beyond December to put the current RP1. You cannot have asked the secured lenders to release, the A's to release 400 million from the security net without telling them what the terms would be for RP1. So the term sheet had to be agreed, and there had to be a lockup for that term sheet. So that's the coincidence of the TSA, the lockup for RP1, and the STID proposal. It's a necessary commercial connection. And under that term sheet, there is the JRC that leads into the supported LUA definition. And the point is simply this. New money can't be compelled. You can't compel existing creditors to lend new money. It has to be by election. The A's don't have to provide new money and didn't have to at the time. They did, however, have entrenched rights. So it was reasonable for them, and there is evidence on this point, to have said, we will not release this amount of money and we will not sign up to RP1, which is only a bridge to RP2, unless you respect in RP2 our rights to have a say in what the terms of that are before it's launched, because those reflect the entrenched rights. Yeah. And so in this case, we essentially have an antecedent right position that justifies the terms of the plan. And the judge has accepted this in his judgment at 63 and page and 275 sub 5. He's accepted that RP1 was a liquidity proposal and the Class A creditors were not prepared to authorise the launch of RP1 and the release of 400 million without their having a say on RP2. Now, there is a decision on my Lord Justice Zacaroli that is a submit of some assistance, and that's a new look case at tab 92 of the authorities bundle. I'm conscious I've only got 5 minutes left, so I'll just give you the point. It's at page 1799.
92.
What's significant about this case, the relevant references are on page 1799. It's the head note issue 3. It's the holding at page 1800 at letter B. And the paragraphs of the judgment are 12 to 14, 248, which refers back to paragraph 14, and 252 to 254. Now, this case was approved in Adler to 196 as to the treatment of the horizontal comparator, which is why it's particularly interesting. It's interesting for the facts because in that case there was a CVA that dealt with the operational restructuring, and that there was a prior scheme that dealt with the financial restructuring. The bondholders had given up their security and were to put in equity, to be equitised, under the terms of the scheme. And that happened before the CVA, and it happened. The CVA then allowed the remainder of the unsecured debt to vote down the landlords. And so the landlords objected, and they said nothing under the CVA was happening to the bond at all, and it was unfair that the bond debt should be used to impose the turnover rents on them. And this was said to be unfairly prejudicial and differential treatment, because if you looked at the CVA only, they were bearing the burden of it. However, because the financial restructuring had occurred before, that was a good reason and a justification and an answer to the charge of unfair prejudice. Now, of course, it's said that the interdependence of an interlocking scheme and CVA is a different factual interdependence from what we have here. We have a STID proposal, a TSA, a release of security, and that's a connection. But it's an example of proper justification for planned terms, differential treatment of the non-participating A's from the B's by reference to a prior step in a prior linked restructuring step. In my respectful submission, there is some assistance to be derived from that authority. Dealing finally with TWL, the essential point of law is on ground 3, but just on ground 2, and very briefly, we highlight paragraph 61 of our skeleton argument, which gives the pertinent references relevant to ground 2. In that paragraph, we point out that ground 2 involves an appeal against the judgment on the basis that TWL was not given the opportunity to participate in bridge financing. We give the paragraph reference to their trial opening skeleton, where they said they did not wish to participate in the bridge financing. And we've also given the paragraph reference to the judgment, where their parent company wrote off their investment as uninvestable. In our submission, it's impossible for TWL to maintain ground 2, given the way it put its case at trial. Ground 2 should simply be dismissed. Ground 3, there is a point of law against, and there's also a point of process, and there's certain points of fact. If I can just canter through these. The point of law essentially disagrees with their skeleton argument, most clearly put paragraph 43. At paragraph 43, they say the court, as its paramount consideration, should look at the benefits a creditor is providing and the benefits on which are conferred on them. As Mr. Thornton put in his submissions, are they giving up enough? The short conceptual point is that's not a horizontal inquiry. You've broken it away from its relative comparison, and you're simply looking at whether that person is giving enough. That's not a horizontal inquiry. That's asking the court to look at the adequacy of the consideration, which beyond assessing whether it's a compromise or arrangement, the court has never done. That's the legal flaw in their case. We go on in that part of our submissions to deal with the observations in Adler as to why elevation mechanics, because an elevation mechanic is simply this. For every pound of new money you put in, a given ratio of your existing debt is elevated and treated as if new money, even though it's not funded. Now, viewed from the perspective of a non-funding creditor, that's not pari passu treatment. And the observation made in Adler is if that a third party would fund the equivalent amount of money without the cost of the elevation, that would indicate that the elevation is not justified as a departure from pari passu. The court need not cast any doubt on those observations to put into question and to reject TWL's submission, which treats that as if it's authority for a review of the adequacy of the consideration. It's a complete misconstruction of what's said. As to the points of process, we've dealt with these at length in our skeleton. The points are, TWL said nothing at trial. Its advocates sat there silent until closing. At closing, we've got their 25-page written closing in the bundle, in the supplemental bundle at tab 36. They spent 4 pages dealing with why they supported the B plan, and they spent the remaining 21 pages dealing with 2 pretty arid points of company law. One was the decision in Savoy Hotels, and as to whether, as a shareholder, they could compel the board to agree to the B plan, and the other was whether the proposal of a plan was within the power of the shareholders or within the power of management. That was the extent of their closing submissions. None of this stuff about ransom terms was put by their advocates to the directors or to my client, Mr. Burns. None of it was put in closing, and yet it's pursued in the most vociferous terms on this appeal. Now, as to the points on the facts, in the 3 minutes I have remaining, we've dealt with this in our skeleton argument. 1 minute, I'm told. At paragraph 19 of TWL's skeleton argument, it does something really egregious. It says the judge found that it was likely that there was third-party funding. It uses the word likely, and it cites for that proposition paragraphs 251 to 252 of the judgment, which you've read. That's where the judge said might, not likely.
Yeah.
They can't criticise the judge and misconstrue the facts he's found. The reason they've done it is because might is a country mile away from the findings they need to suggest a ransom term. The final points we've got in the skeleton are at this figure of 158 million. That's on the B's evidence. It's in the judgment at paragraph 129. It's in a table where the judge sets out everything under the A plan, everything under the B plan. The difference between the two figures is 158 million. Now, even if you don't adjust that for the A backstop, which is an adjustment we've explained as to why it had to be made, there's a 10% price difference between the A plan and the B plan. If you adjust it, it's a 7% price difference. Another way of looking at it, it's 158 million is 0.62% of the debt stack, of which TWL is at the bottom. So for TWL to say that it's affected by the differential costs of the A plan relative to the other, what they say, competitive funding that they supported, and to characterise that 7 or 10% difference as giving rise to ransom terms, in my submission, is completely unsustainable, and ground 3 should be rejected in its entirety. The same applies to ground 4. My Lord, those are my submissions.
Thank you very much, Mr. Rowland. Well, we'll take a 5-minute break then.
Rise. Felt like it.
I will shout it.
I've seen your notes, and I thought, is that what Amy's doing now?
Sorry, did you say, Max, would I like a minute? Sorry,
I bought enough of the whole call. Alright. You're very welcome. Good luck over here. I haven't got the cyanide one. There's always one.
He has sent that before.
no, but
So that's the facts on
God.
All rise if they will.
My lord, I'm going first on the replies. Okay. I'm going to deal with valuation as I did in opening, and I will do so at some speed, but these points are important. Can I start with three general points? The first is to put the valuation issue in its proper context so far as this appeal is concerned. As your lordships know, we proceed on the basis that the no worse off test has been satisfied. So the reason valuation matters is because on the judge's view, of the legal principles, he's essentially shut the Class B out of fairness considerations based on his finding that the Bs were out of the money. He said in the relevant alternative, we say in fact the correct test is genuine economic interest in the going concern.
Yeah.
Mr. Phillips would address you on that. We say it's nothing to do with the alternative at this stage of the inquiry. But be that as it may, the important point about valuation is that if it has the consequence that the judge considered that it does, it has very, very stark implications for the Class B creditors. Now, on either basis, whether it's right to look at this on a going concern or on a relevant alternative basis, we say the judge's findings on valuation in this case are not safe findings. And we're not obviously seeking a retrial or anything of that sort, but pursuant to the principles in Henderson and Foxworth, paragraph 67, we do submit this is a case where the judge has failed to take into account relevant evidence, and so this court should review the decision in that light. And we say, again, Mr. Phillips will address you on this, but the relevant standard we say is in fact all we need to show in this context is that we have a real, as opposed to fanciful, economic interest pursuant to My Travel and Bluebrook. And on that basis, we say we certainly meet that test. So in terms of what we need to show on this appeal, we don't need to show that Dr. Grunwald's valuations are correct, nor do we need to show that the correct valuation was Mr. Wearising's with the specific adjustments that we pointed to added on top. We simply point to the quantum of those adjustments to demonstrate to the court that the errors that we've identified in the judgment have a very material and indeed significant impact on the valuation question that the judge was considering. So Mr. Smith says, he started by saying our whole approach on this appeal was wrong, and we respectfully disagree. We say all we need to show is a real economic interest, and this chimes, if I may say so, with an observation from my Lord Justice Zacaroli, that these are not intended to be valuation trials. It would be impossible for a judge in Mr. Justice Leech's position to conduct a full valuation trial when the company was insisting upon a judgment being produced within a matter of days. And with respect, it's simply not appropriate to arrive on some scientific basis on a concrete valuation of the company, particularly in a world where we know the company is now appealing the final determination to the CMA. So on any view, these numbers that were the subject of evidence below will change in the future. And secondly, and more importantly perhaps, this is RP1, not RP2, and there is currently a bidding process which is ongoing precisely to determine the equity value of the company. And we do submit, when one's considering the fairness question, to arrive at a scientific, concrete valuation, it is really a misguided approach. And so we do respectfully submit. The judge refused to take up our invitation below. A point we made below repeatedly was that he could have decided this on the basis that the company hadn't discharged its burden of proof. That was said in closing submissions, for example, day 4, pages 167 and 170. But the judge, with respect, decided to reject that point and to treat this like a valuation trial and arrive at a hard number, which he does at paragraph 194 of the judgment. Now, having done that, we respectfully submit he had to get it right. And for all the reasons that I've outlined, we say, in fact, he made some fundamental errors. Now, the second general point I want to make is that this is not a case, or our appeal that doesn't run into a problem that the judge was simply evaluating evidence and ultimately the judge preferred Mr. Wearising's evidence, and so this court shouldn't go behind any of the findings. In fact, the errors that we refer to in this appeal are matters that the judge failed to deal with entirely in the judgment. I'll come back to this, but the ASM point, there is nothing in the judgment about the aggregate sharing mechanism, even though it's common ground, that's part of the regulatory framework. There's nothing in the judgment about the inconsistent inflation assumptions, and there's nothing about the cost of debt and the true-up mechanism. And so we do respectfully submit it's not right to say, well, the judge, having accepted or preferred Mr. Wearising's evidence, that's the end of it, and this court can't go any further, because in fact our points are ones which arise out of the regulatory framework. So it's not just a case of which expert was to be preferred. In fact, Mr. Wearising's modelling was at odds with the regulatory framework in relation to inflation and cost of debt and so on. And so we do respectfully submit the judge was not entitled to accept Mr. Wearising's evidence to the extent that his evidence was completely contradictory to the regulatory regime. And the third general point I'd like to make is Mr. Smith began by making the interorum submission that these models are all very complicated and this court couldn't possibly start to look at individual components of the model. Now, with respect, that's a bad point, because in fact, it is true. The only example of that point Mr. Smith gave was the ASM and the overspend point. But if your lordships had my submission on day 1, what we were saying was that the judge was wrong to use the DDR figures on TOTEX, but even if that were the correct figure, which resulted in a 4 billion overspend, then the other side of the coin was the ASM. So we were. It's not a case where we were doubling up, as it were. Mr. Smith was trying to say, well, if you change one thing, something else changes. In fact, on the TOTEX issue, we were saying once the 4 billion overspend has been accepted, then the judge was obliged to take into account the ASM. Yeah. But on all of the other points, there's no, as Mr. Smith described it, whack-a-mole issue. They are simple components of the model. And that's not surprising, because both experts, in fact, use broadly the same modelling and the same methodology. And so this is a case of saying that these errors mean that Mr. Wearising's own numbers were wrong in these respects. And so this is a matter which this court can look at and scrutinise very carefully. Now, turning to the individual errors very, very quickly, on the ASM, I've just made the point that that was quantified at 750 million, and the judgment is silent on that. So having accepted the 4 billion figure, the difference between the final determination and the DDR figures, we do respectfully submit the judge was obliged to consider the impact on Mr. Wearising's valuation, particularly in circumstances where Mr. Wearising admitted orally that the ASM would be triggered. That's day 2, page 178. And all he could say was it was uncertain, or a sensitivity, or that the 750 was encompassed within his range. But that misses the key point, which is if it's within his range, then one should be looking at his high case number, not his central case. So that would actually immediately take his number up from 14.7 billion to 15.8 billion. And as I say, the judge, having dealt with the DDR figures point, is simply then silent on the consequence of that, which is that the ASM kicks in. The next point is inflation. Again, judgment is completely silent on the inconsistent assumptions. Of course, the judge...
Sorry, that's just factually wrong. Paragraphs 183 and 184 of the judgment.
Well, I can't really be interrupted. Mr. Smith's had a long time on his feet. But on the inconsistent assumptions point, the judge is silent, my lord. The judge deals with inflation, but he does not deal with Dr. Grunwald's fundamental criticism that what one can't do is have a 3.3% inflation rate in the discount rate, but have 2% increase in cash flows. And if that point is simply nowhere in the judgment, and it's the key criticism that's being made by Dr. Grunwald. And it's interesting, Mr. Smith took you to Dr. Grunwald's first report, paragraph 357, but he didn't take you to 358, which is where she makes that fundamental criticism. And it's actually a very basic point of discount cash flow modelling, that one can't use inconsistent assumptions on one side of the equation and then use a different number on the other. What the consequence of what Mr. Wiersing did was to use 3.3% in his discount rate, but only 2%, which is the Crabtree, the company's own model, has an assumption of inflation at 2% on the cash flows. Now that is an outcome that would never happen under this regulatory system, because as both experts confirmed, Ofwat makes these companies inflation proof. So Ofwat adjusts cash flows to reflect actual inflation, which means that the Crabtree model, which has an assumption of 2% inflation, in fact, what Ofwat will ultimately allow the companies to do is to increase those revenues to the tune of, let's say, 3.3%, if that's what actual inflation turns out to be. Now, that point was never grappled with by the judge. It just simply does not feature in the judgment. And as I say, this is not a case of the judge being entitled to prefer Mr. Wiersing on this, because both experts were agreed. If one looks, for example, at Mr. Wiersing's first report, at internal page 36, supplemental bundle 216, or Dr. Grunwald's paragraph 347, which is supplemental bundle page 548, both experts agreed that Ofwat adjusts for actual inflation. And in those circumstances, there was no basis for Mr. Wiersing to proceed on a 2% cash flow inflation basis. And that had an impact of 1.7 billion on the valuation. And in my respectful submission, it was not a matter that the judge could properly fail to deal with. And insofar as the judgment is silent on that point, that's a matter which this court should look very carefully upon. All the judge deals with in the paragraph that Mr. Smith just referred to is he deals with the anterior question, or the distinct question, of whether it was right to use the market rate or the Bank of England rate within the WACC figure. But that wasn't the fundamental criticism, which is a basic point of modelling, and we've included the McKinsey extract, the textbook extract, in the authorities bundle, because one can see it's just an obvious point. And the only other answer to this from Mr. Wiersing, which Mr. Smith took you to this morning, was his paragraph 4.5.4 in his second report. But that paragraph one needs to read very carefully, because it's very confused. Mr. Wiersing seeks to suggest that 3.3% is the current view of long-term inflation, whereas in fact there's something, according to Mr. Wiersing, which is a long-term view of long-term inflation. We say with respect, it's completely incoherent. He confirmed, when giving evidence, that he had used 3.3 in his discount rate and 2% on his cash flows, and we say there was no basis on which the judge should have accepted that approach. And in circumstances where it has a 1.7 billion impact on valuation, at the very least, the judge should have set his reasoning out in the judgment. And a very similar, turning to the next point, cost of debt, it's conceptually a very similar point, because, again, it's worth 636 million. It's a true-up mechanism which features in the regulatory system. So this isn't a matter for the experts to debate between themselves. It's part of the regulatory system. Now, Mr. Wiersing confirmed orally he hadn't taken this into account. That was day 2, page 159, and his only answer was, well, an investor wouldn't have taken this into account. But that's not the point. If one's modelling cash flows, one has to recognise that Ofwat will allow the companies increased revenues to reflect an increase in the cost of debt. And Mr. Smith pointed to a passage in the cross-examination, the oral evidence of Mr. Wearising, where he said, well, the reason I haven't taken it into account is because all companies get it. But with respect, that's a hopeless answer, because Mr. Wearising's, the basis on which he has increased his cost of debt figure between his first report and his second report is because the market price of debt or cost of debt has gone up. One can see that in his second report at 3.2.1, supplemental bundle page 888. Now, he's taken the market cost of debt and said, well, I'm going to increase my WACC figure, discount rate figure for Thames. And if that's the case, then the mere fact that the cost of debt has gone up for all companies doesn't mean that he can exclude it when doing a discount cash flow model for the company. So it simply doesn't engage with the point at all. Then coming to the multiple, again, common ground, this was worth 5 billion on the valuation, which just shows the danger, in my respectful submission, of trying to treat this as a precise science in such compressed circumstances. There was 5 billion at stake on this point. On its own, the multiple would have meant the Bs were plainly in the money, even without the other points I've referred to. Now, the judge struggling with this point says he's going to have to cut through it, paragraph 188. And as I said, by reference to Symmetra, Lord Justice Males, it's fine to take a shortcut, but not if you get lost. And with respect, the judge did get lost, because at paragraph 190, he made a very significant error in this context. He thought that Dr. Grunwald, in advancing a 1.2 multiple, was assuming significant outperformance. And that's simply incorrect, because both experts proceeded on the basis that there would be a decade of average performance. So the first point here is we say the judge's finding is unsafe because he proceeds from the wrong starting point. He then goes on to dismiss all of the precedent transactions. Now, in relation to the precedent transactions, I'd make 2 points. The first is they were all in excess of 1.1 times. That was not disputed. That's Dr. Grunwald's figure 3.25 at supplemental bundle page 562. Even where, this is important, even for those companies that had been underperforming, one needs to look at her chart very carefully to see some are underperforming, some are overperforming. Here we're talking about an assumed average performer over a decade, and there is not a single transaction as low as a 1 times multiple. So the only point here, which the judge relied upon or could have relied upon, was the point that the historic transactions are unreliable because the regulatory framework was different. Now, the only point of difference that Mr. Wearising and Mr. Smith have referred to is the rules on financing are changing. But with respect, one can't simply take on board one aspect of the change in regulation and simply dismiss all of the historic precedent transactions. One needs to look at all of the changes to the framework in the round. And as Dr. Grunwald explained at day 2, pages 167 and 182, there are all sorts of other changes which make it more likely that there'll be outperformance in the future. And none of this, my lords, none of this appears in the judgment. And so we really do say here, if the judge wanted to cut through and take a shortcut, the obvious answer was to take 1.1, for example, and that would have put the Bs in the money. Finally, on the cross-check, just like to make a few points on the cross-check, because we say, first of all, the experts were experts in valuation. They were not instructed to consider the debt market. They were instructed to value, on an enterprise value basis, the company. There's in fact a separate field of expertise in relation to the debt markets. So we do respectfully submit it's completely unfair, for example, for Mr. Smith to say, well, Dr. Grunwald had no answer to this point. The experts simply weren't actually supposed to consider these debt market issues. And in fact, an expert in the debt market could have come along and made the obvious point that debt markets do not tell you anything necessarily about the underlying enterprise value. It's a well-established and well-recognized proposition. The second point is that in this particular case, the judge doesn't deal with the point that if Mr. Wearising's right in his valuation, 14.7 billion, then why are the B bonds trading at 15% of their value? this is a very important point which Mr. Smith didn't deal with and couldn't deal with orally today. He says, well, look at the substantial discount on the A prices. That must tell you something about the enterprise value. It must mean that the Bs are out of the money. But in that case, how can you explain why the Bs are trading at 15%? They can't have it both ways here. And so we say it's an unreliable cross-check, both as a matter of principle and on the facts. We also say this point about the debt markets being an unreliable cross-check is expressly recognised by Mr. Justice Mann at My Travel, paragraph 57, where he says they're completely different things. And he also, and the final point on cross-checks, is one might have valuable cross-checks in other cases, such as Bluebrook, where there are different approaches to valuing a company on a going concern basis. So you might use a discount cash flow model and a market approach, for example. But here, the cross-check was by reference to something which is completely different. So, my lords, in relation to valuation, we do say there are very significant consequences in terms of being excluded from the fairness considerations, and the judgment simply isn't safe, and the judge didn't deal with a number of important points. Unless I can assist further, I apologise for taking that so quickly.
My lords, Mr. Smith's position is that only rights of economic value, in other words, payment in a distribution, should be taken into account. If you don't have a right to a distribution and you are out of the money, your entitlement is de minimis. Of course, one question that has to be asked is how does that help Mr. Smith's argument? His focus on rights to payment makes no sense when the relevant alternative is a SAR, which is not a distributive purpose. This is not like a normal administration or a liquidation. Our position is that is too narrow, and the court should take account of rights to contribute to the benefit of the plan. In a distributive insolvency, the question whether a creditor is in the money is usually determinative, and essential evidential questions of valuation are relatively straightforward. If the assets were realised and distributed, where does the value break in the waterfall? Mr. Smith's argument was that in every case, the value of the creditor's rights was assessed against their rights in a distributive insolvency process. If that was right, that would mean that the old scheme cases are of no assistance to us in the present case, because in the present case does not involve a distributive insolvency process. The same error led Mr. Smith to submit that in an interim plan there is no restructuring surplus, on the basis that it does not result in distributions. And Mr. Justice Leech was led into error by that same submission. Mr. Smith's submission was in reality that no economic interest meant no horizontal comparison, and that submission also led Mr. Justice Leech into error. My learned friend Mr. Smith still believes in the extreme submission that was rejected in Adler. If you're out of the money, as the shareholders were in that case, you get nothing. And he said it again this morning. He tried to say that he wasn't advancing that submission on the basis that in a horizontal comparison, you would give de minimis value in exchange for the rights of the out of the money creditor. But he continues to miss the point. The question is not what payment the creditor would get in the relevant alternative. You look at what the creditor contributes and what they get, and you ask whether that is fair. You do a horizontal comparison with the other classes. On Mr. Smith's argument, if you're out of the money, you don't do the comparison. And you can see this quite clearly, I won't turn it up, the judgment, paragraphs 245 and 246, you can see that Mr. Justice Leech was led into error by this submission that was advanced and continues to be advanced by Mr. Smith and Mr. Al-Attar. We describe it, rightly in my submission, as the out of the money mantra. We see it in several cases in which the point was simply repeated and accepted without contradiction or debate. Occasionally, judges have said that they weren't sure about it. However, it isn't until now that it's been properly considered. Turning to the horizontal comparison, the court will consider whether relative contributions to the plan justify the differences the creditors receive. Lord Justice Snowden in Adler said at paragraph 167 that you cannot be prescriptive about that test. In other words, you can't identify now all the circumstances in which this might arise in any future case. It will depend upon an evaluation in each case. The court will ask, in this case, whether what the bees get is fair, taking into account their contribution to the plan. And as your lordships know, that is the entrenched rights and the maturity rights. And my Lord Justice Zacaroli put to Mr. Smith that those rights must be worth something. And I've been reflecting on that. And I want to test it, first of all, by reference to the maturity rights. And my lords, your lordships have seen the X-Plan, the schedule in the X-Plan, which shows that in the period up to, and perhaps go back and look at it after we've finished, in the period up to September, there are 2 A-class debts, there are 2 B-class debts. The A-class debts are 599 million, the B-class debts are 125 million. There are then 2 sets of debts that run to November, but your lordships can look at that. So let's test it. In my learned friend Mr. Smith's world, the Bs have 2 bonds that fall due to, for maturity during the period to September 2025. Those bonds would give rights to payment totaling 125 million. In Mr. Smith's world, you say you are out of the money. You would not get paid £125 million in a distribution, ergo, no account of this right is taken in the horizontal comparison. On his case, a de minimis value would be put on the right. In the correct world, the bonds mature during the period to September 2025. If they were not paid, there would be an event of default. If there was an event of default, the company would go into a standstill and would go into a SAR. The right that the bondholder, the B bonds in this case, have contributed isn't the right to a distribution. It is not causing the company to go into a SAR. That is the contribution to the extended platform. It is what the Bs get in exchange for that that has to be fair in comparison to what the As get for what they contribute. And I've given your lordships the numbers. Or, and this is very important, alternatively, the company could decide that they did not want to affect the rights of the B-class bondholders. They could have chosen to leave the B-class bondholders out of the plan, leave the maturing bonds out of the plan, and they could have funded payment of maturity at a cost of 125 million during the period between now and September. If they're paid, there's no event of default. Now, for the purposes of a horizontal comparison, those maturity rights have value, and that value is not de minimis, and because they are out of the money. And I hope, my lords, your lordships will take that away. The entrenched rights also make a real value contribution to the plan, and that value is not made de minimis if the Bs are out of the money. So I hope, my lords, you can see that this out of the money mantra, when one is assessing what the Bs have contributed to this plan, on either any of those bases, it is not de minimis. Can I turn to the Bluebrook test? On top of that, my learned friend Mr. Smith was wrong about Bluebrook, which is a going concern case. He said that valuation was assessed in an insolvency alternative. As we explained in opening, My Travel is an outlier, and in Bluebrook it was not in an insolvency process. The valuation was a going concern valuation. The test is whether the creditor has a genuine economic interest determined on a going concern valuation. not by reference to a relevant alternative. In Bluebrook, the valuations were going concern valuations for use by an administrator in a pre-pack. They were not insolvency process valuations. They were not valuations in an administration, and Mr. Smith is simply 180 degrees wrong to say that Bluebrook was a case where the valuations were in an insolvency or in a relevant alternative. And my lords, perhaps if you could just take this away, read paragraph 77, Little Roman 11, which is on page 232, because that completely undermines my learned friend's submission. When the entity is a going concern, the test under the old scheme cases is whether the opposition party has shown a real or more than a fanciful or theoretical economic interest. The learned judge in this case did not assess the evidence on that basis. Taking it from my travel at paragraph 54, where a party can show they have a real, not fanciful economic interest in the company, then on one way of looking at it is the company has failed to show on the balance of probabilities that the party has no economic interest. And it's not answered by asking the out of the money test as formulated by my learned friends. It's not answered by the no worse off test. And it is a question which will be answered, real or fanciful, will be answered by a range of possibilities on that sort of evidence. And for the reasons given by my learned friend Mr. Singler, and you'll be pleased to know I won't repeat them, we say that on that the evidence of Dr. Grumwald, the criticisms of Mr. Wearising are real and not fanciful, such that the Class B have a real economic interest in the company. And of course, my lords, your lordships have already heard what I've said, just by way of example, by the 125 million. I just want to say something about the consequences of applying the wrong test. And this is very important. Any higher test, any test that says you absolutely have to determine this, gives rise to a valuation trial, which this process is not suited to. This is a Part 8 claim. This is not a determination of complex factual questions. This is not a final determination at trial. There is no disclosure, considered preparation of experts' reports, exchange of views by experts, full cross-examination, and time for the parties to help the court to assess it and for the judge to consider his judgment. But nor should it be. Valuation should not be a determinative factor, but a factor that will be considered by the court when considering whether the restructuring surplus is being shared fairly. It does not need to be determined with absolute precision. Being out of the money for the purposes of fairness is not a binary question. It isn't that if you're out of the money, a fairness comparison does not take place. But if you're in the money, it does. Within the range, you will look at all the relevant factors. It is not like section 901C4, a test which is more stringent, as I explained in opening, and which will be considered at convening. And this is another plan case that has been completely out of control. Your lordships will know that in the McDermott case, apparently the costs were something like 250 million. Thames, we know the professional costs are running at 15 million. There is no need to conduct a full trial. And remind your lords that Mr. Justice, Lord Justice Zacaroli, Mr. Justice Zacaroli, refused to sanction the plan in Hurricane without a full trial, without full cross-examination. If you apply the right test, real as opposed to fanciful, you wouldn't have a full trial. And it's not uncertain when you come to fairness. And I explained that transcript, day 1, 45.1 to 46.2. And it would be perfectly sensible in that context to challenge key inputs. 2 short points. First point, clarification of the legal tests. There's been too much confusion and elision of the tests. I invite your lordships to clarify them. 901C4 is no genuine economic interest in the going concern, not the relevant alternative. 901G5, assenting class receive a payment or have a genuine economic interest in the relevant alternative. Dissenting class must be no worse off in the relevant alternative. Then discretion, is it fair? They are different tests, they are different provisions, and it needs to be tidied up because there has been far too much elision and confusion. Finally, it's not final. I'm sorry. Our focus on the liquidity control right, I'll just mention this very quickly, and the liquidity and facilitation rights. Mr. Smith relied on 59, 60 is important, and the answer to Mr. Alatar's point is we've got entrenched rights in relation to those as well. He relied on the A's entrenched rights, we've got entrenched rights too, and it's got nothing to do with being in or out of the money. Mr. Smith said you'd look at every clause. I'm sorry, that's simply not right. You don't go through and look at every clause. You go through and look at the clauses that are relevant to the question in question. In case. And Mr. Smith several times said the A class had the rights anyway, ignoring, both he and Mr. Alatar completely ignored that in a SAR they don't have those rights. Then 2 quick points. The 400 million waiver, my learned friend Mr. Smith said non-participating creditors make a contribution by releasing 400 million. Can I just refer you to the transcript, day 1, pages 97, 20 onwards, in which we made submissions on that. And finally, the extension of the JRC. My learned friend, Mr. Smith, I think gave you the wrong impression. He tried to downplay it on the basis of the ability to extend. And in answer to my Lord Justice Zacaroli's question, he said that if you extend it, then payments continue to be made. The point your lordships need to appreciate is the payment schedule under the first tranche, the money stops in August. So an extension applies to 2 months of payments. In order then to get more money, one has to have entered into the LUA to get into the second tranche. So with due apologies to my learned friends for taking as long as I did, those are our submissions.
My lords, I'm just going to give you some references. So firstly, to deal with the suggestion that we didn't run the ransom point at trial, it was in our skeleton argument at trial. That's a supplemental bundle 2, tab 32, page 1085, paragraph 6, 7, 6 to 8 and 16 to 17. In 16, we made the allegation of ransom, and in 17, this goes to the point that perhaps my Lord the Chancellor was concerned about, that we were alleging a misconduct or something. It's very clear from 17 what we mean by ransom. So if I could invite you to look at those, and also our closing at section G, which is the supplemental bundle 2 at tab 36, page 1146 onwards. The only other point I wanted to make is that we've made very clear that we're not alleging, we're not complaining about not having a right to participate in the senior funding. We've always made clear we're not. I didn't put it that way in my submissions. The reason we drew out the distinction in our second ground is that the judge made a slip in the judgment at paragraph 249, fourth line, where he said that all of the plan creditors are equally treated because the plan creditors are entitled to participate in the senior funding. I think he meant to mean the A's and the B's. That's why we drew the distinction in parenthesis in our grounds of appeal. We are not alleging and never alleged that we are going to participate in that funding. And then just going to hand over to Ms. Peters to make comments.
My Lords, with advance apologies, I'm going to have to speak at great speed as a result of the time and those who've gone before me. I have 3 points to make. The first is clarificatory. It relates to a point my Lord Justice Zacaroli put to me yesterday. The second and third are reply points, which relate to my learned friend Mr. Smith's arguments yesterday and today on the economic ownership argument and the treatment of out-of-the-money creditors. I won't take you to any documents, I'll simply give you the references for purposes of the transcript. In relation to the first point, my Lord Justice Zacaroli asked me a question yesterday about whether we accept the second sentence in the judgment, paragraph 246, which, as my Lord put it, is less stark than the first sentence. The sentence is this: in Virgin Active, Mr. Justice Snowden held that the views of creditors who were out of the money should be given little weight, even though they had voted against a plan. The transcript reference for that from yesterday is page 43, line 18. To be absolutely clear, we do not accept that the judge's paraphrase accurately reflects paragraph 249 of Virgin Active. It collapses the second and third sentences of that paragraph into each other. And to be absolutely clear, we do not accept that a binary proposition that out-of-the-money creditors' objections to a plan should be given little weight in all cases is correct. In reply to my learned friend Mr. Smith's submission about Virgin Active paragraph 266 yesterday, we deal with that in our skeleton argument. That's footnote 53, core bundle, page 369. It was a slightly inaccurate summary by the judge, with the greatest of respect to him, of paragraph 249. But the important point, and it is a very important point, is that to the extent paragraph 266 uses the term weight, it is plainly talking about the weight as between the landlords and secured creditors, because it would be, in the case of Virgin Active, the secured creditors who were affected by the equity not being impaired. That is vital, and it's clear from the language of paragraph 249, and it's also clear from paragraph 252 of Adler. If your lordships look carefully at paragraph 252 of Adler, which I would say with the greatest of respect to his lordship is more precisely drafted than his judgment in Virgin Active, it explains that any question of weight was by comparison with secured creditors who had acquiesced in the shareholders' equity retention. This simply underscores in our submission the problem with taking this as a binary rule. In this case, the question is, should the court place little or no weight on junior creditors' objections to the cost of the new loan when we say the company and junior creditors will ultimately bear this cost? The answer, we say, is plainly no. The second point, this is my learned friend Mr. Smith's economic ownership argument, which he developed yesterday. I have 2 points to make. First, we say this is an attempted revival of an argument which has already been rejected by this court in Adler. I would ask this court to read very carefully the following paragraphs of Adler, in which the economic ownership argument was the conceptual foundation for my learned friend Mr. Smith's argument that shareholders should be expropriated. That's at tab 118 of the authorities bundle. The first paragraph of Adler is paragraph 243. That was the first step in Mr. Smith's economic ownership argument. The second paragraph is paragraph 253. That was the second step in his argument, where he applies his economic ownership argument to the facts of Adler. After that, paragraphs 258 to 266, that's where this court dismisses the economic ownership argument and expressly, and this is very important, expressly dismisses the argument that it would achieve a result which would be commercially the same as the position out of the money creditors would have been left in a my travel scenario. Paragraphs 267 to 269 of Adler, the paragraphs to which I referred this court to yesterday, they deal with the logical extension of my learned friend's economic ownership argument, which is expropriation. Very clear, expropriation. And those paragraphs emphasise the differences between the my travel scenario and Part 26A. And we would submit, by reference to those 3 paragraphs of this court's decision in Adler, that the key difference between a my travel scenario and Part 26A is that in a my travel scenario, the company is preserved. The company goes into administration and it is preserved. And out of the money creditors retain their claims against the company. And so they retain their remedies, which may be remedies against an administrator, or it may be remedies against the company's directors in relation to the failure of the company. Under a plan, the company goes forward free of the out of the money claims to the extent of their impairment. But the out of the money creditors lose their claims, and importantly, they lose their claims against the directors if there are releases which have that effect. And that is obviously of critical importance in this case. So we say the legislative intention under section 901G was not to codify my travel. The second point is we say the judge was wrong to accept the plan company's argument that the Class A creditors are the economic owners of the group in relation to this plan. Now, one has to ask, as I did yesterday, what are they the economic owners of? It cannot be the Thames Water Group. That's the submission which the judge accepted, and we say he was wrong to accept it. And the reference for that is judgment paragraph 219 and judgment paragraph 255. This is a bridging plan in which the business of the company will continue. It is not a distributed plan. Unlike a My Travel situation, the relevant alternative SAR is not a distributed process. So again, I ask the question, what are they the economic owners of? And in my submission, my learned friend, Mr. Smith, had no answer to that question. He didn't even attempt to give the court an answer to that question. The third and final point, the reference to this is the transcript from yesterday, page 174, line 21. My learned friend, Mr. Smith, made the submission that there is somehow a general rule that out of the money creditors are never entitled to more than a de minimis consideration. We say that is plainly wrong. It is not what cross-class cramdown was intended to achieve. It is not the legislative intention. There is nowhere in the statute does one find that intention. When the court decides whether to impose a plan on dissenting creditors, we say the court does need to consider whether its treatment of assenting and dissenting creditors is fair and justified. There's no binary rule they should be taken out for nothing. It is a fact-specific assessment in each case. It would otherwise reduce give and take to a mere jurisdictional technicality. It isn't a mere jurisdictional technicality. Give and take is at the heart of the Part 26A jurisdiction. I referred yesterday to Professor Patterson's article, which we say is compelling in support of that submission. I refer to it again to make good that submission because I don't have time to go through the reasoning in any detail. But in any event, my learned friend, Mr. Smith, has already answered this for me in his submissions this morning. He said this morning, in another context, a plan is needed where the company cannot get contractual consent. Part 26A is a statutory replacement for contractual consent. That was my learned friend, Mr. Smith's submission this morning. Now, that, my lords, is precisely Professor Patterson's thesis and precisely the argument that we put forward today. Under Part 26A, the company cannot impose the deal on junior creditors without recourse to cross-class cramdown, so it comes to this court and it asks this court to impose the plan on the junior creditors. If a creditor says the deal is not commercially reasonable, taking into account what the assenting creditors are getting over and above the relevant alternative, the court cannot ignore those objections. Under its cramdown discretion, the court has to decide whether the deal is justified and appropriate to impose on the dissenting creditors. This court's decision in Adler simply didn't decide this question because it wasn't an issue in that case. My learned friend, this is my very last point, my learned friend referred yesterday to paragraph 277 of Adler and this court's use of the word modest amount. I would ask your lordships to read paragraph 277 carefully. Paragraph 277 was not suggesting that out of the money creditors should only be paid a modest amount. It is obviously a very fact-specific question. It is underscored by the fact that in Adler, the shareholders were permitted to retain 77.5% of the equity. Now, if there was value in the equity, 77.5% is not a de minimis amount. Unless your lordships have any questions for me, those are my submissions.
Thank you.
Well, my lords, I think this is the definition of a graveyard slot. And I will take the compliment that most of the submissions coming from the other side today were focused on my case. And I'll do what I can in the time available. I think what may assist my lords the most, judging by the questions that have come from the bench, is to say something briefly on releases, something very briefly on costs, and if there's time, blot, if that would be of assistance. Now, on releases, my lords have seen the ground of appeal that Mr. Maynard makes on that, and it is addressed in our skeleton argument, the core bundle of pages 403 to 404, and we essentially make the point of those paragraphs that we say the test is one of necessity, and that the combination of the fact that this is an interim plan and that claims are being given up by the company against directors and advisors is significant and is an expansion of the previous jurisprudence about when releases will be given. I'm not going to go there in the time available, but at paragraph 72 we draw attention to a
Hong Kong decision, which specifically discusses when it's necessary for companies to give up claims against directors, and I would respectfully endorse the reasoning in that case, if my lords have time to read that after the hearing. The Matalan case, I mean, it's important to note that was an extempore uncontested hearing, and the focus again was on releases by creditors. And if one looks at the consequentials judgment in this case, paragraph 6 and 7, nowhere is there an assessment of whether the releases by the company against directors are necessary. Effectively, it said that they would assist the plan, not that the plan would fall over if those releases aren't given. And again, my learned friend on his feet today, in my respectful submission, wasn't able to explain why those releases by the company against its directors and its advisors are necessary. Now, on costs, there is an element of cakeism in this, to coin a phrase from a recent Prime Minister, which is that the plan company is very keen to bank all the factual findings on valuation, but then when it comes to the findings of fact, primary findings of fact, it wants to reopen anything that's unfavourable to it. Can I just make a few points about this? So firstly, my case below and on this appeal, it's not just about the costs of the super senior funding, but of the plan as a whole, compared with the relevant alternative to the plan as a whole, which is special administration. And that's why it feeds into my submission about the costs of the plan being greater than special administration, given the finding that the judge made below, which we say shouldn't be disturbed, that one would have the same length of time for both the plan and the special administration. It's not an expert point. All of the cases that my learned friend refers to are cases about valuation evidence. This isn't a valuation point at all. My client's not concerned with valuation. It's about the primary findings of fact, about what the company is going to spend the money on, or indeed has spent the money on. I don't have time to go through the cross-examination of Mr. Cochrane. The judge below described it as careful and forensic, and I don't accept the criticisms that my learned friend made of that. In the course of that cross-examination, certain facts were established, they were accepted by the judge. There was no re-examination of Mr. Cochrane, there was no response to it in closing, and we say the judge was not plainly wrong because he wasn't taking into account points that either weren't explored in re-examination or in closing. Now, there's one other aspect of costs I'll briefly mention, which is the complaint that the judge focused on the costs, assuming a 6-month bridge. Now, the plan company's evidence was that the equity raise in RP2, which obviously continue in tandem, will likely conclude in around 6 months, and that remains their evidence on this appeal, as I understand it. I'll just give my lords one reference, which is to Mr. Cowlishaw's report in the supplemental bundle, tab 22, page 809, where he sets out the costs running for 7 months. And that actually shows that the costs of the plan increase even further. So the OID goes up, according to Mr. Cowlishaw, by 23 million. The make-whole increases by 54 million and so on. It simply isn't, in my respectful submission, given the limited time I've had, fair for this court to disturb what the judge found below in circumstances where I can't go through the transcripts and show my lords what points were or were not put. I make a similar point about Mr. Cowlishaw. I did put to him that he wasn't independent because he was an advisor to the company personally. And I did, in closing submission, submit to the judge that, in effect, by refusing to answer certain questions, he was an advocate for the cause. I also put to Mr. Cowlishaw that there was a fundamental difference between the special administration of a water company and the special administration of Bulb Energy, in circumstances where Bulb had no assets and no guaranteed revenue stream because it didn't have a monopoly.
So I'm going to have to come back on this suggestion that Mr. Cowlishaw refused to answer certain questions. I mean, that is categorically not the case. I mean, if that's going to be, that is a serious allegation.
He didn't. I asked for various yes or no questions. He didn't give it to me, and I said to my lord.
I speak for myself. I'm unimpressed by any suggestion that he wasn't independent or that he was hung around because there's nothing in the judgment that even begins to suggest that. The judge saw the witness who gave evidence, and he appears to have thought the witness was an honest and reasonable expert.
My lord, I wasn't suggesting he wasn't honest.
Where does this point get you? If he was an honest and reasonable expert, so what if his company had advised the company on other occasions.
Well,
It's just, you know, I'm
my
sorry,
lord,
Mr.
all I'm
Davies,
seeking to-
these are very, as Mr. Smith just said, these are very serious allegations.
No, my lord,
And they
it's not
can't just be
intended to
sort
be.
of plucked out of the air and reply, frankly.
My lord, it's not.
Just by saying, oh, well, you know, you haven't had a chance to read all my cross-examination of this witness.
Well, my lord, all I can say is that.
As I said to you yesterday, you're here as an intervener, you're not a party to these proceedings.
My lord, I understand the point. I'll leave it there. I have referred, my lord, to Mr. Heiss's evidence on.
No, I'm sorry
certain
about that, I'm
points.
sorry, that just slightly irritated me.
My lord, I understand. I'm going to move on.
Slightly terse.
My lord, that's fine. I understand. It's been a long appeal for us all. Can I just deal very briefly with blots, if my lords won't?
Well, I don't know, is it what's within no indulgence, really? Quite. Yeah. Right. Anything else?
My lords, just briefly on blots, you have our case. We say that, I mean, effectively, this may come down to a debate about label. We saw this in Halcro itself. The question is, do you say blot is just something technical, or do you say it's the residual discretion that the court has in any case? And in Halcro itself, Mr. Justice Foss thought that was a distinction without a difference. We say that BAT and Halcro are clear that one can take into account the impact on third parties, even if their rights aren't affected by a scheme or a plan. And so, for my learning from Mr. Alatar to get to where he needs to get to, I think he's inviting the court to overrule those parts of BAT and Halcro. And on the relevant alternative, we say again, if the key question is what would happen if you do not sanction, and that ultimately guides the exercise of discretion, then one can take into account the relevant alternative under whether you call it the residual discretion or the block, whatever the label is. And that then takes you into the world of considering what we say are the public interest objectives in the 1991 Act. My learned friends relied on the co-op and the equitable life cases. Again, both of those were unopposed cases where, so far as I can see, there wasn't detailed consideration of what blot does or does not mean. And certainly nothing in them which suggests that the decisions in BAT and Halcro were incorrect on this question of definition. My lords, unless I can be of further assistance, those are my submissions.
My lords, I was just rising to say thank you very much. Thank you for hearing us so quickly. Thank you for your patience in hearing us over such long days. And I'm sure everybody else joins me in that.
Yeah. Hang on.
Mr. Smith, this is a question for you, I think. This is not suggesting in any way what the decision may be. But what if, having considered these arguments on the release point, we come to the conclusion that we don't like, for whatever reason, the release by the company? It would be a tragedy for the tail to wag the dog in this case.
Well, that's
What's the way out of that?
so we dealt with this in the respondent's notice, in fact. So if you go to core bundle 2, paragraph 11 of the respondent's notice, page 317. So in the further alternative, if contrary to the position of the respondent court,
Yeah, I thought I'd seen it somewhere.
so our position on that would be, is if you're against me on that and you take the view that the release provision needs to be modified, then
It's open to us to modify.
you modify it, but we'd invite you in effect to re-exercise the discretion to sanction the plan.
Well, thank you all very much indeed. As we indicated earlier, we are obviously reserving judgment. We will do the best we can to give you an answer to whether the appeal is allowed or dismissed, hopefully during the course of next week. We're certainly not going to produce a judgment during the course of next week. If in due course, when you get the judgment, on the usual terms, please pay attention to the embargo at the top of the judgment. The whole point of having it in draft is so that you can pick out any typographical errors, not inviting the court to reconsider its substantive decision. And if in due course you could also provide us with a draft order, we'd be grateful. So, and finally, despite having slightly lost my rag towards the end of the day, I'd like to thank you all, on behalf of all three of us, I'd like to thank you all for the extremely impressive way in which you've presented this appeal at very short notice. And that's not just you and your juniors, but also I know the legal teams on all sides are very much teams, so it's not just the people who've been the mouthpiece, as it were. Thank you all very much.
Thank you all.
All rise if able.